explosive oral arguments before the Ninth Circuit Court of Appeals in the case involving Donald Trump trying to federalize the National Guard and then send the troops against the people of Los Angeles. I want to talk about here, though, Harry, how it's really smoked out Donald Trump and his regime's main argument across the board that we've seen them make before, but that they are asserting more strongly. It's the authority of a dictator. It's that in anything that could be tangentially related to the Article 2 powers as a commander-in-chief, that involve the military in any way, that involve foreign policy, whatever the role of commander-in-chief is, courts can't even question, according to the Trump DOJ, what Donald Trump does. Even if what Trump does is completely contradictory to the law, the Trump argument before this 3-judge Ninth Circuit Court of Appeal panel, you have zero authority to question it, because what the panel was saying is, hey, this statute that Donald Trump purports to invoke to federalize the National Guard, it's called 10 USC U.S. Code 12406. And this statute says you can only federalize the National Guard under certain circumstance. So the judges, the Ninth Circuit, the same way the federal judge below Judge Brier was saying, so is your position that we can't even question whether or not Donald Trump was wrong to invoke this statute? Because you go through 10 USC 12406, like laws, it has elements to it. And if you are to invoke it, you have to show, one, that there is an invasion by a foreign nation. There's no invasion by a foreign nation taking place. Two, there is a rebellion or a danger of a rebellion against the authority of the government. It's been about 400 people in total arrested in Los Angeles, like 0.003 of the entire LA population in a very small area. Overwhelmingly, these are peaceful protests. This is not the kind of rebellion to call the National Guard. It hasn't even escalated to the top levels of the LAPD and sheriffs. And the LAPD and sheriffs said, in terms of our escalation protocols, we are nowhere near National Guard. I mean, heck, it looks more unruly when the Dodgers win the World Series than what we've seen over here. And then number three, the other only way the president can invoke this, the president is unable with the regular forces to execute the laws of the United States. And it's like, you can execute the laws of the United States. Then it says that orders for these purposes, if you can meet one of those elements, shall be issued through the governors of the states, or in the case of the District of Columbia, through the commanding general of the National Guard. So the argument by California and seemingly by these judges is, we're reading this statute, and if we were to apply the law, it seems that you did it incorrectly. So Donald, so Trump DOJ, that's what the question was, are you saying that we can't even question you? And even if you're wrong, you have unfettered discretion to interpret this law however you want. And even if you're wrong, that becomes the law. There's no room for judicial review. And then on every question like that, the Trump DOJ lawyer, Shoemate, says, absolutely, you have no authority to even be hearing this case. There were 2 Trump judges, 1 Biden judge on this panel, 3 judges on this Ninth Circuit panel. So the question, DOJ, is it your position that the court has no role in reviewing the president's discretion to call the militia? There's no answer. There's no role for the court to review the discretion. Judge's question. So is the decision to deploy the troops, can they be reviewed even if a president gives no reason for his decision? Are we not able to review it? If the president just says 10 USC 12406, I'm not even telling you why, I think so, can we not question? Correct. That's correct, because the statute is unreviewable. No courts at all. Harry, this is a very dangerous proposition. The lawyers for California says It's a terrifying proposition because that just means no laws apply and it's dictator rule.
It is dangerous, and the issue is huge. It goes well beyond the already very important circumstance of the conflagration on the streets in LA, which, as you say, is the sort of thing always handled by local law enforcement easily, not an occasion for federalizing the National Guard. But I want to pick up on a couple things you said, one across the board and the other tangentially. You're absolutely right. Anytime the DOJ lawyer was pressed, so are you saying, fill in outlandish proposition here, he would say, yes, Your Honor, that's exactly what we're saying. And he didn't even support a tangentially limitation. He actually said, you've named the three things according to which Trump has the power to do certain presidential acts. They said, well, what if he doesn't even use one of those three things? He just does it because it's Tuesday. Answer, that's right, Your Honor, cannot review it. In other words, if they were to uphold the power that Trump is asserting, he could, in any circumstance at all, universities, federal government, just simply invoke this power, even though it has nothing to do with anything. It would be the ultimate do whatever the hell I feel like on behalf of Donald Trump. Now, what Brier said in his opinion, I have a long Substack on this, Ben, yesterday, is he said, look at this statute carefully. It says, whenever there are one of these three things, then the president can do the functions that are laid out in the statute. That means, though, that first clause means it's a normal judicial function to say, are one of these three things here? And I think the only one possible would be a rebellion actually present. He said no for very strong reason. He goes through what a rebellion means, among other things. You're trying to overthrow the government, you're armed, goes through every single dictionary and says, we ain't got a rebellion here. If judges can't do that or something like it, the implications, not just in LA, but in blue cities across the country and in other areas, are immense. This is just what Trump is going for. Now, notice the parallelism to what happened in the Alien Enemies Act, as Brier himself does. They played the same card. They said, it's up to the president, and it cannot be reviewed whether there is an insurgency by a foreign country, which there sure doesn't seem to be. Supreme Court said 9-0. That's what the judiciary does. It is the Trump administration is going to try this again and again. And if it wins even once, like here on this argument that I can use this because sort of Humpty Dumpty style, a word means whatever I say it means, then we are off to the races on authoritarian power, where he can just play that card again and again and again, saying, oh, this is a rebellion, that's a rebellion, here I am back federalizing the National Guard. So it really is the prospect. The California attorneys did not understate when they said the implications if you let him do this. So now it's at the Ninth Circuit. The court seemed to me to play its cards pretty close to the vest. Two Trump appointees, as you say, both of them reputation is not as being completely wild-eyed. And with any kind of foresight or respect for, the legal regime, you can see the dangers here, and it would be, I'm sorry, catastrophic to permit Trump this kind of power. And the issue will be what the Supreme Court does. But you have a really top-notch opinion by Brier that he produced in very short order that lays out why it's the judiciary's job to decide this and why, in fact, it's not a rebellion. And it is just as you say, Ben, the actual game that the administration is about is exactly the effort to just tell the courts to stand down and do nothing, because if Trump says it's a rebellion, or even if he says it's Tuesday and I like this statute, the courts have no role to play. That is both a breathtaking and a terrifying prospect. That is what's on the line here. I would say at a minimum, based on their questions, that the judges see that's what's on the line here. You have higher courts and the U.S. Supreme Court being pretty damn solicitous of arguments about executive discretion. This is what they didn't do in the Alien Enemies Act cases. If they do it here, it is just as bad in another way. The odds, the implications couldn't be more important. Will the court greenlight what the Trump administration is really trying to say, which is anytime we invoke this power, you can't say a word about why we did it, anything that might have been in Trump's mind, etc. That is not the law, by the way. Even if you care a lot about foreign policy and the like, this is a domestic policy issue. The actual analysis of political question under the Baker v. Carr factors says that this is the sort of thing, of course, judges can do. If they say otherwise and hold with the Trump administration, it is a dark day and a giant step on the road to authoritarianism.
You look at the statute 10 U.S.C. 12406, federalizing the National Guard. It has those elements: invasion by foreign nation, rebellion, or president can't execute the laws. And he needs this, and he's got to work with the governor. Your point is so right. With the Alien Enemies Act, this other kind of archaic, statute that had not been used the way Trump tried to, Trump wants to use it, that uses the language whenever there is a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States. So Trump uses these types of statutes and says, we call it that. It may be Orwellian, dystopian. We may be making it up. We could be lying. It doesn't matter. Guess what?
Tough shit. Foreign policy, national security, good night. Exactly.
You don't get to call us out. We say invasion. So when Trump uses that language at his speech, when Stephen Miller uses that language, the idea is the authoritarian takeover, because you use that language and then you take the guts out of the law, and then you basically say, aha, there's no reason for judges anymore, dictatorship. So they're making, in conclusion, that we should have a dictatorship or a military dictatorship argument. That's happening now. And the last line of defense is, the Ninth Circuit and eventually the Supreme Court and what their ruling is going to be. Harry, you and I are going to be doing one more hot take. I want to remind everybody, subscribe to the Talking Feds YouTube, the Talking Feds Substack, and the Talking Feds podcast. Just search Talking Feds on YouTube. Subscribe. Help Harry get to 1 million subscribers. Thanks, Harry.
Thank you, Ben.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.